let's open this key session in which we had the pleasure and honor to have Harry Hansmann with us. And I think I really don't have to spend any word for presenting the personality that is not and perhaps the major reference point in law and economics and organization, I would say, because for you has been since a long time a major reference point, but now it is also for say us more into the management and organizational community, especially thanks to his work on corporation and corporate governance. So and today it seems from the title that he will bring us through a journey among the some basic fundamental concepts in institutional and organizational economics. So we are all keen to hear you. Welcome and thank you.
Thank you, Anna. It's a great pleasure to be here, at least virtually. And I won't waste more time on introductions here, other than to state my gratitude for being in this community. And I will proceed to my talk here. Let me make sure I'm set up here. All right. I hope you can see the slides.
Yes. May I add that people may ask questions, remind you that people may ask questions just in the chat, even whenever you want to start putting your question there, but we will go through them at the end of the presentation.
All right. Normally I would invite questions during the talk, but I think that's going to be very awkward with the Zoom technology. So I'll talk first and then we'll have a conversation second.
Probably better.
Okay, so let me begin. If one is involved in the corporate governance business at all, as I am, for better or for worse, the contemporary literature on corporate governance and on organizational law and economics in general has long focused, for half a century it has focused with singular intensity on what we think of as the managerial agency problem. This is the problem of getting the managers of an enterprise to manage the enterprise in a fashion that is for the benefit of those whom the organization is intended to benefit or who own the organization. The effort involved has been for economists to try to design mechanisms or institutions that will control managers and make them operate in the best interests of shareholders and other beneficiaries. Crockman and I, in this essay that you are about to hear a summary of, believe this emphasis is misplaced and that the managerial agency problem is really a second order problem in the economics of organization. Excuse me while I get myself organized to. So there are, now I have something blocking my screen up here a little bit. Does everybody have this?
Yes.
Okay, then I'll just talk my way around it. There are three fundamental agency problems that face any organization and that have to be dealt with in that question of design. And these are, first, preventing the organization from behaving opportunistically toward its creditors, that is, allowing the firm to position itself so it can receive credit. Second, preventing managers of the organization from behaving opportunistically toward the organization's owners. And third, preventing controlling owners of the organization from behaving opportunistically toward the non-controlling owners of the enterprise. So these, we think, are the three principal problems in organizational design, and of these, the second, the famous managerial agency problem, we believe is the least important. In particular, we think it's second order in importance compared to the other two agency problems we mentioned here, the creditors problem and the intra-owners problem. And we think in particular that the intra-owner conflict is extremely important and perhaps most important of these three, and also by far the most neglected. So we try to offer in the paper that follows evidence for this proposition and some perspective drawn from that analysis into some contemporary problems, such as the debate over corporate purposes, ESG, and the like. So our approach is both economic and historical. It involves a kind of free-form methodology of the sort that Oliver Williamson might have appreciated, but the world didn't appreciate until he came along. We're being bold here. We're dealing with great spanses of time and a rather casual methodology. We appreciate the risks involved in this. We're gonna plow ahead nonetheless and hope we come out with something that will prove itself useful. In particular, we are going to examine the evolution of organizations and of mechanisms to constrain managers for the last 700 years, since the 15th century. And we believe that this survey shows the extent to which the managerial agency problem has been important in organizational structures and the extent to which it has not been important. And in doing this, we take a survivorship approach to organizations. We assume that that organizations that survive over long periods of time and in large numbers are relatively efficient compared to other alternative forms. This is a mode of analysis, which is one has to be careful with, of course, and we believe that it works in this particular case. But the success of the method depends on how well it organizes the world for each of us. And you have to ask yourself whether you think this is an insightful way to approach organizations or not, whether the mapping we give you is a useful guide or just a walk in the woods. This lengthy historical approach, going over centuries, requires us to create broad categories into which we can put the relevant actors throughout history. We can put actors doing similar things at different times into the same category. And for this purpose, we begin by dividing all the persons who interact with an organization into three categories. The first category, the three categories are beneficiaries, owners, and managers. So we'll look at each of them first. Beneficiaries. These include, first of all, owners, people who clearly have an ownership right in an enterprise, a corporation, or a partnership, or whatever, who have the two characteristics of ownership, which is joint possession of both a share on the organization's net returns and a voice in the influence in the, or to some degree of control in the management of the organization. So we're going to include among beneficiaries I can see I've got, well, I will go ahead. We're going to include among beneficiaries owners of the organization. Forget the little title at the top of the slide here. And beneficiaries, who are people for whom the organization was created, for whom it was intended to serve, but not necessarily people who are owners or have control over the organization. And people who benefit from a charity might be the most obvious example. Victims of disasters who receive help from the International Red Cross would be beneficiaries in our categorization here. And they are people who in a sense have a claim on the services of the organization, on the net returns of the organization, or on the activities of the organization, for whom the organization is to be managed. They would include, as I say, persons served by nonprofit organizations such as the Red Cross, residents of non-democratic municipalities, municipalities that have their officials appointed by somebody other than the citizens, would be, in our mind, beneficiaries of the city and the metropolitan organization. And policyholders in large mutual insurance companies who have no meaningful voice would, as we will discuss, would also be beneficiaries. And as I go along here, we're throwing together owners, straightforward owners, together with beneficiaries, as I call them, into the category, broader category of beneficiaries. I will often just use the term owners when that would be appropriate when we're talking about owned enterprise. This will become a little clearer as we move along. I see. Okay. Managers, that's our second category. These are people who, such as board members in a corporation or senior officers in an organization, who have general authority to manage the organization's business, to commit it to contracts and so forth. Finally, we have creditors, another mixed category that includes basically all persons who have a contractual relationship with the firm. That is, people who rely upon the firm to perform its contractual obligations and who will suffer if it doesn't. So these three categories are not mutually exclusive. A partner in a general partnership, for example, under both the law of 15th century Tuscany, which we will look at, as under the law today in the United States, is in our terms, a beneficiary of the organization, is entitled to receive a share of profits of the organization, which qualifies them as a beneficiary. The organization will be managed for the partner's benefit, but the partner is also a manager of the partnership. All partners are, in the default view of partnerships, are fully authorized managers of the organization. And they might be a creditor as well. They might extend credit to the partnership in which they're a partner. So a single person could be all three of these things: manager, creditor, beneficiary. So organizational forms. We characterize organizational forms in terms of the relationship among their beneficiaries, their managers, and their creditors. And we focus particularly on the relationship between beneficiaries and managers, which is the managerial agency problem. Our effort is to find out how serious that has been as an historical matter here. And in particular, we're going to look at four mechanisms, we'll call them mechanisms, by which the beneficiaries of an organization can influence the actions of the organization's managers. That is, how they can protect themselves from the managerial agency problem. And we call these four mechanisms, respectively, exit, voice, duty, and scope. These mechanisms may be put in place and enforced by law, by either mandatory law or default rules governing the organization, or they could be, excuse me, got a call here. These mechanisms could be put in place by law, or they could be established by contract. Well, as the title suggests, which you recall would be exit, voice, the first two words in our title here. We follow many other students of organizational design, excuse me. So we follow many other students of organizational design in focusing, including exit and voice, among the four control mechanisms that we are going to analyze here. Hirschman, let me say, Hirschman, I hope needs no introduction. He wrote in 1970 but his book is a famous book on exit, voice, and liability is still well known today. It is very conspicuous in the legal literature, where a citation count shows him still an enormously popular figure, and shows his influence growing, or his citation count growing through the 2000-2010 decade, after which it's fallen off just a little bit. So I hope you all are familiar with this. In any case, Hirschman was interested in how organizations, he was interested in the beneficiaries of organizations and the organizations that serve them, and how the organization might be brought to serve them better. He did not, however, look at matters of business management. And so, but others of his followers have not been so reticent. And there is a large literature out there invoking the concepts of exit and voice, his famous concepts, to analyze managerial agency problems. We're going to label these followers the Hirschmanites. The Hirschmanites follow Hirschman himself in making the argument that there is a trade-off between exit and voice in designing organizations, that that the two are complements rather than substitutes, and that an organization with high voice, which we'll come to, means high levels of direct control, often needn't have exit rights, and vice versa. We think this is wrong, and that exit and voice, as we will describe them, are in fact complements rather than substitutes. An organization with strong voice, where beneficiaries have strong voice, is an organization where they also have strong exit rights. But this will become clearer as we move along. I use the word Hirschmanites to distinguish it from Hirschman. We are talking not about Albert Hirschman, who never said any of the things we're attributing to the Hirschmanites here, but the Hirschmanites themselves, the followers of Hirschman intellectually, who think they are followers of Hirschman, but perhaps are not. We have four mechanisms we're going to look at here. The first is what is analogous to Hirschman's exit. That's withdrawal rights. It involves the freedom of beneficiaries of the organization to withdraw from the organization. We break this down into four levels of severity, or of strength, as it were. And the first is individual cash out right. A beneficiary who has that right has the right to leave the organization at any time and to take from the organization her share of the organization's assets, if she has some share of assets, and or a share of the assets intended to serve her. So a good example would be the modern mutual fund, where, at least in the United States, anybody who invests in a mutual fund can withdraw their money from the fund within 24 hours with no explanation offered. You just take your money out and leave the fund, and you go invest someplace else. This is the traditional default rule for partnerships. That is, any partner at any time, historically, or in the default organization of the firm, could leave the firm at any time and take her share of the partnership's assets with her, forced dissolution, partial dissolution, or complete dissolution on the partnership. So there's another individual cash out right, very important. Small businesses often create cash out rights in the forms of so-called buy-sell agreements that give one party the right to force the other party to either buy them out or let them buy the other party out. So these are very strong exit rights. There are other forms that are weaker. We have three of them here. We have so-called collective liquidation after term. This is an organization with a lifespan. The most obvious example are private equity firms and hedge funds in the United States, at least, where the organization is designed to have a termination date, typically 10 years, at which point it will dissolve, sell off its, distribute its assets to its investors, and disappear. So if you invest in a private equity fund or a venture capital fund or some kinds of mutual funds, of hedge funds, you have the assurance that after 10 years, your money will be returned to you, no matter what happens. You have a right to get that money back after 10 years. And of course, there are firms set up for longer or shorter periods of time as well. Our third level of exit is free transferability. That involves the saleability for shares of business corporations that trade on the market, for example. And finally, we have no withdrawal. That involves situations in which beneficiaries of an organization or owners of an organization cannot withdraw their share of the net assets under any circumstances. When I say their share of net assets, withdrawal means two things. Withdrawal means no longer personally participating in the firm, and it also means taking out your share of the capital of the firm. Often it's easy to stop associating with the firm. You just don't go to the meetings anymore. But it's harder to get your share of capital out, and that is the true touchstone of exit rights, is your ability to get your share of the firm's capital distributed to you so that you can take it away and invest it elsewhere. Then we turn to voice, or at least what is analogous, most analogous to Hirschman's concept of voice, which is a notion of control, basically. We break down control rights or voice into three types. There's direct management, in which it's the partnership rule, in which every partner has the right to join in the management of the business equally, with equal authority. There's delegated management. The most obvious example is business corporations, where the beneficiaries have the power, or the owners have the power to choose the managers of the firm, not to direct them what to do particularly, but necessarily, but to choose them. And the management of the firm is therefore delegated to these people chosen by the firm's owners. And finally, autonomous management, in which control resides entirely in the hands of the firm's managers, who are themselves either self-appointing, they appoint their successors, or are chosen by some outside authority. Nonprofit foundations are a good example of this. If you donate to a nonprofit, you have no role in the governance of the institution, and the managers of the institution are typically either self-appointing or appointed by somebody outside the organization. Okay, finally, we get to fiduciary duties, not finally, but next topic is fiduciary duties, which we call just duty. These are restrictions on a manager's ability to engage in self-dealing transactions. We are combining two types of rules. Well, no. We are going to break this down into several types. There's strict fiduciary duties, moderate and mild. Not very imaginative names we know, but let's look at them briefly here. First of all, let me say under fiduciary duties, duty is a slightly misleading concept here, because we are not involved with affirmative duties that people in the organization have, that managers have imposed upon them, but rather with limits on their ability to engage in self-dealing transactions, where our notion of duty here is a notion of constraints on the ability of managers to be self-serving, to be opportunistic. And so we start off with strict rules. So we ignore affirmative duties, a duty of obligation to the organization of some sort, because we think they don't really exist. And we can talk about that later, but let me just emphasize that we're looking at what we call duties here, are bars on self-dealing transactions. So the strictest form of this is, it takes two forms. One is these a non-waivable distribution on a bar on distributions to controlling persons. the so-called non-distribution constraint. This characterizes nonprofit foundations. If you give money to a nonprofit, give money to the International Red Cross to help disaster victims, neither you nor the managers of the Red Cross, the beneficiaries of the Red Cross, but in particular the managers of the Red Cross, have no rights to appropriate that money at all. They have an absolute duty not to engage in self-dealing transactions. That is, they cannot buy things from the organization, the Red Cross in this case, nor sell things to it. They cannot engage in self-dealing transactions. In other words, where they're on both sides, have influence on both sides of the transaction. And this rule basically defines the field of nonprofit organizations, which are characterized by precisely this. There's no class of persons who can legitimately take distributions from the organization, and that makes it a nonprofit organization. There's also another set of transactions we throw in into the strict category here, and that's an absolute bar on self-dealing transactions by managers unless approved in advance by all beneficiaries. The private trust and the general partnership have strict duties of this character. I won't dwell on them further. Continuing with the third mechanism, which is duty or fiduciary duties, we have a more moderate version of it, which is self-dealing transactions are barred to the managers unless they are approved ex ante by non-conflicted managers or ex post by beneficiaries. This rule is a little tightly specified, I'm afraid, and sounds legalistic. It comes out of American law. There is a more general version of it, which we think applies well to organizations throughout history. But the notion is that you can engage in self-dealing transactions, but only if you get approval from a relatively disinterested party connected with the firm. Then we go down to, let me say that's the duty imposed upon Delaware business corporations in the United States. It achieves high visibility because of that in the United States. Then the third gradation of duty is what we just term mild here, which is simply a bar upon fraud. That is to say, the manager cannot extract money from the organization by fraud, by cheating or lying or inducing behavior that dishonestly. It basically says, one version of it is that the manager doesn't have to, if he knows that he's dealing with somebody else in the firm in setting up a transaction to his benefit, and he knows that other person is misinformed about the situation, he, the manager who is engaged thinking of self-dealing, has no duty to correct mistakes that he knows the other party is making. He has a duty not to affirmatively lie to that other person, not to affirmatively mislead them, to engage in fraudulent behavior. But that's a very low bottom limit here, and that characterizes the duty of good faith and fair dealing that is the U.S. default rule for contracts. And it also characterizes the minimum duty for members of a limited liability company in most of the United States. The fourth mechanism, where we got it blocked here, let's see if I can get it. Well, this is, if you could see it, it says it's called scope. It's the scope of authority given to managers in managing the organization. What kind of activities are available to them to choose and what are not. And it's best seen by looking at examples. We have it broken down into narrow, moderate, or broad. Narrow scope is the situation where the managers of the organization are tightly constrained in terms of the activities they can undertake. The most extreme example is the special purpose vehicles that are created for asset securitization, and that is the bank or other trustee who sits between the bondholders and the debtors in a widespread asset securitization. The bank or whoever the trustee is has essentially no freedom in how to move. There's a long document of dozens of pages that specify what they're doing in every possible circumstance. The idea is to leave them with no discretion whatsoever. So that's narrow, moderate. Would be a situation where the organization's purposes are set out broadly in its founding documents, its charter, or perhaps in the regulatory law of the applying to the field that it principally operates in, such as insurance law. It specifies the line of business that the organization is entered into, as can legitimately pursue, but leaves it to the managers of the organization to decide precisely how to do that, how to sell life insurance if that's the purpose that's involved, et cetera. And finally, we have broad scope, and here managers are given extensive discretion to determine the purposes to be served by the organization, and how to serve those, how to pursue those means, those mechanisms. I'm sorry, not mechanisms, those ends. Typical example is a business corporation, which in the United States at least typically is chartered, quote, for any lawful business purpose, unquote, which means any purpose that is not criminal. So there's essentially no constraint on the managers of a business corporation, so long as they avoid crime, as to what they can do with the funds. So we're going to turn now to to deploy these form mechanisms in looking at the range of so-called organizational forms that we're going to look at. And we're going to look at three historical moments here, and rather arbitrarily chosen, you will see. We're going to look at Italy in the middle of the 15th century, and at the end of the Middle Ages and the beginning of the Renaissance. We're going to look at the United States in 1900, and we're going to look at the United States today. So three snapshots in time. What these have in common, a reasonable answer might be very little, but we think that's too cynical. In 1450 Italy, as in 1900 the United States, the society had reached a point where a given set of organizations that served the society had matured and established let me say, a solid form, a consistent form that they would keep for some time. And that's true of Italy in 1450. It's true of the United States in 1900. Our third era is the United States today. This is not a period of stability, quite on the contrary. It's a period of rapid organizational change. We aren't quite sure where it's going, but we think we can illuminate that as well. And we're going to try. We picked it because we're here. That's why we picked 2020, to see what this analysis can tell us about the current age we're in. So we'll look first at a table showing the this is the world of 1450 in Italy, Florence, I guess in particular it would be. And we have arranged this chart in two dimensions, two of our four dimensions. The two dimensions are, of course, exit and voice. And up and to the left is high, and low and to the high beneficiary independence or autonomy or strength of control mechanism. And in the lower right, it is weak. So let's look at what we've got here. Again, we have exit on the left axis, the vertical axis, and with no withdrawal rights, that is, you're locked in at the bottom, the weakest possible rights you can give a beneficiary, and the strongest possible rights, which is the ability to cash out on any moment's notice. being the strongest rights that beneficiaries can have vis-a-vis the firm's managers. And likewise for control, which runs across the horizontal axis. At the top, you can see, again, we run from direct management, which is the most protective form of a beneficiary can have the advantage of, to, on the right, autonomous management. That is, the firm is managed by people who are appointed by somebody other than the beneficiaries to conduct the business for the beneficiaries without the beneficiaries being given a choice in the matter. And we've tried to populate this table with just about all of the organizations that one would find in, the important organizations one would find in 1450 Italy. Not all of them by any means, but the principal ones. And let me say, we're looking here not just at commercial organizations, we're looking at other organizations that one thinks of outside the commercial realm. We're looking at monasteries, for example, which we think are very instructive. We're looking at guilds. In a more ambitious earlier version of this paper, we looked at families too. We put that aside for the moment, but maybe we'll be inspired to come back to it with a little encouragement. In any case, we think we apply this analysis universally to organizations, whatever the type may be. The first thing one notices in looking at this table is the anti-Hirschman quality of it, the anti-Hirschmanite quality of it. The organizations here are loosely run from the upper left-hand corner to the lower right-hand corner. That is, the populated cells are either up in the top here, to upper left corner, or in the lower right-hand corner, or on the diagonal between them. Oops, I got us in the wrong era here. Okay, here's a little better. I didn't mean to run us into 1900 so quickly. We chose it among the 1450 organization, simple then compared to today, and pretty stable. And we find the first thing we find, as I say, is two things. Organizations here are in the upper left-hand corner or the lower right-hand corner. In the upper left-hand corner are firms like the partnership. I'm getting blackouts here. Like the partnership, which we break down into two forms, the general partnership or the partnership for a term. They're very similar. They're in the upper left-hand corner. And then in the lower right-hand corner, we have nonprofit organizations. And we have not much in the middle. The center squares are largely unpopulated. But in particular, we have a strong positive correlation here between voice and exit. If you got high voice, you got high exit rights. If you got low voice, you got low exit rights in our characterization of these rights. So here we first see the anti-Hirschmanite character of the world. There's more to it than that. There are other differences between the upper left-hand corner and the lower right-hand corner. The organizations in the upper left-hand corner are small. They're partnerships and so forth, typically 2, 3, 4, 5 people, members in the partnership. And the lower right-hand corner, these are largely nonprofit organizations, and they're often very large. A monastery might have hundreds of monks. A guild, a trade guild could have hundreds or presumably thousands of members. These are large organizations. We mentioned municipal corporations in the title here in the chart. I'm going to skip them for the moment, like the family. There's a third difference between the upper left-hand corner and the lower right-hand corner organizations. And those are that the ones in the upper left-hand corner, as I say, are very large, and they are all commercial. The ones in the lower right-hand corner are, the ones in the upper left-hand corner are small but commercial. In the lower right-hand corner, they are large and non-commercial. So what's going on here? we think that what these reflect is really the creditor rights problem, the problem of establishing credit, making a firm creditworthy. There are two different strategies here toward making firms creditworthy. In the upper left-hand corner, we have personal liability. These are partnerships largely in the upper left-hand corner. And their basic rule is that all partners, all managers are liable up to the limit of their personal wealth for any debts of the organization. That's a very strict rule, very hard to avoid the rule. This makes, of course, the firm much more creditable, much more creditworthy than it would otherwise be, because the creditor has the right to all the assets of the firm's managers if the organization fails to pay. This also has an effect on other rights, control, for example. Why do we have high control in these organizations? High voice. Well, we think the problem is the intra-owner conflict of interest problem. In a small firm, like a partnership that is engaging in large transactions relative to its assets, you want to be very careful about whom your partners are and how they're behaving. And one of the best ways to do that is, of course, to have strong control rights over them. And another way to do it is to have strong exit rights, so that if you suspect that one of your partners is committing the firm to improvident debts, you can leave the partnership. You can't avoid debts incurred up to that point. You take them with you. You're personally liable for all of them, but you can at least get away from being exposed to further depredations by a partner who's out of control and who's giving the firm away and all of its assets. So we get strong exit rights where we have unlimited personal liability, and we get strong voice rights where we get this. So voice and exit rights are both very high here to deal with the creditor problem, the creditor rights problem. In the lower right-hand corner, there's another strategy for making firms creditworthy. These are firms that are very large and that have fixed assets, typically non-redeployable. It's most obvious in the monastery, where where there's no withdrawal admitted at all once one joins the monastery, when it's committed for life. This is very helpful in making a firm creditworthy, because if you extend credit to the firm, you know it's not going to disappear tomorrow. It's still going to be there. It's going to be there for your lifetime and your children's lifetime, in fact. As for control, there is minimal control over these organizations by the members. In a monastery, let us say, who are the beneficiaries? The beneficiaries are the monks who take it. The organization is set up for the benefit of the monks, for their spiritual needs and so forth. And it is they who the organization is supposed to serve, but they are not given participation rights in making the choices. The abbot of the monastery is typically chosen for the life of the abbot, is chosen by the monks, but that's the end of the monk's authority. For the rest of the life of the abbot is free of sanction by the members, by the monks, and in fact, monks aren't even allowed to exercise their literal voice to complain. There are rules against sniping and gossiping, especially about the abbot in these monasteries. Monasteries were wildly successful. They had a long-term credit problem, let us say. A common transaction would be one in which a local wealthy landowner, gives, maybe upon his death or maybe before his death, to the monastery a large plot of land that he has owned in the past, and the monks will use it to farm it. In return for donating the land, explicitly or implicitly, the monastery will promise to say prayers for the landowner and his family for the next 150 years. Now, this is a high trust commitment, obviously, because the landowner won't be around 150 years to make sure the monks are doing it. And the monks have every reason to shirk on it. But the monks are in no position to benefit from shirking on their obligations. They've taken vows of poverty. They live in rooms that are identical and that are not of their own design. They have no personal assets, and allowed to have no personal assets. And as I say, are locked into the organization for their life. There's no exit. So this gives and they're not allowed to marry. This means the monks have nothing they can do with personal assets, even if they could manage to design a transaction that would benefit them. They can't hide or keep or use anything that they surreptitiously take from the firm. And they can't have legitimate children to whom they can pass their assets. So they have no bequest motive. So, and these organizations are very large, and they have organization-specific assets. They're very large, and their assets are typically land and buildings, which one cannot redeploy easily. They aren't movable. You can't steal them. You can't walk off of them in the night, as opposed to many of the things that the partnerships dealt in, like gold work and so forth. So we have two very different sets of organizations here. The large organizations on the lower right-hand side, which have very strict rules against self-dealing and very little democracy, very little voice, very little control on the part of the beneficiaries. And on the other hand, we have these small business firms, partnerships typically, which have highly redeployable assets in general, are inherently risky for creditors, it would seem, and need to bolster their creditworthiness by committing their personal assets, which in turn means that they want to have control rights and hence they show up in the opposite as the opposite of the monasteries. All right, I want to move along here. We've got, I've only got about 10 more minutes to use up here of your time. So let me try to get to later periods. Here's the United States in 1900. It's a different society, of course, but some things remain the same. The at-will general partnership is still up in the upper left-hand corner there. And in the lower right-hand corner are nonprofit foundations, the contemporary universities and hospitals and so forth, that are libraries that are the modern descendants of the large medieval nonprofit institutions, the monasteries, etc. The Yale Law School was built to look like a monastery, and it behaves like one in many ways. There's even a cloister to walk around in if you want. We find here the one big change from the world of the 15th century is that things begin to fill in the middle. We still have nothing in the upper right-hand corner and nothing in the lower right-hand corner, lower left-hand corner. That's the Hirschman axis, the Hirschmanite axis, I want to rush to say. Organizations are still spread along the diagonal that runs from the upper left-hand corner to the lower right-hand corner. That show high correlation between voice and exit. But we've begun to fill in the middle, which we didn't have before. And what fills it, of course, is the business corporation, at least in its early phases in 1900, where almost all business corporations were privately controlled somehow, controlled by its founder or by a large shareholder, or a small group of family who together owns the dominant share of the firm. let me point out that in the 19th century, there were no organizations where control could be bought in the market. That is a later development, and these firms were all privately controlled. Some of them had outside shareholders, some of them did not. Most of them did not have outside shareholders who were unrelated to the managers of the firm. So they were small and medium-sized enterprise for the most part until you get to things like John Rockefeller's Oil Trust or Carnegie Steel Trust and so forth. I want to move on, however. To get to the contemporary United States. Here we see showing up in the upper right-hand side, or upper right-hand corner, let me say, for the first time is an organization that fills in an off-diagonal corner, a left-right diagonal corner. And what is that? That's the limited partnership without a term. These are familiar today in the so-called open-end mutual fund. A typical mutual fund in the United States, and I think it's common throughout the world as well, has very, very strong exit rights for the beneficiaries, the investors in the fund. You can take out your money usually within 24 hours notice. You can withdraw immediately. They have governance mechanisms. They have voting mechanisms for the managers of the mutual fund, but they are basically useless. They're dictated by law, but the law is, but the forms, though everybody goes through the ritual of creating boards of directors for mutual funds and so forth, they have no meaning really, other than as nuisance litigation sources. Because if you don't like the organization, the smart thing to do is to take your money out and leave it, to exit. So, so we have high exit organizations and low voice. Well, doesn't that destroy our anti-Hirschmanite thesis here? And we would argue no, because these mutual funds don't really belong in the upper right-hand corner as they are deployed. Something else is going on out here. And what we're seeing is that the relationship between investors and business corporations has changed. For the first half of the 20th century, or extending back into the 19th century that we just looked at, companies were owned by their shareholders and controlled by their shareholders. The situation has changed with mutual funds. Individual investors now no longer directly hold shares of stock in the companies that the mutual fund holds. They own stock, they own shares in the mutual fund, which in turn owns stock in the operating companies. The result is that investors in business firms, in business corporations, tradable business corporations, have been stripped of their votes and of their exit rights in the firm, in the operating firm. If I'm unhappy with what General Motors is doing, and I know that General Motors stock is held in a hedge fund, in a mutual fund that I invested in, selling my stock in the mutual fund is the only form of exit I have. But it's a trivial form of exit so far as as far as General Motors is concerned. I'm not withdrawing much capital from them. I'm withdrawing some capital from the mutual fund, which is perhaps an index fund where some small fraction of 1% of their investments is in General Motors, and General Motors won't notice my departure or the departure of a large number of its shareholders, of its investors, as it were, because they aren't disinvesting just from General Motors. They're disinvesting from the market. and it sends no signal to the, no effective control signal to General Motors. The, there's no voice either, is no exit nor and no voice, because as a shareholder, you don't own shares in General Motors. I don't own shares in General Motors, and I don't have any rights to go to shareholders meetings. Those are held by the mutual fund, which generally doesn't exercise them. And so if you look at the operating organizational form out there, the operating organizational form is not the mutual fund, but the mutual fund that and its investments. And it's the company that invests shareholders and the investors and the managers of the operating companies is extremely remote. There is no way to send a message to them by voting. You have no votes in General Motors by virtue of having them in your portfolio in your mutual fund. And as I said again, you can't send a message to them by withdrawing from them in particular, because you can't withdraw from them in particular. You have to withdraw from every institution, every company that your mutual fund has invested in. So really, the mutual fund belongs somewhere in the middle of our squares here, if it's viewed as a combination of two organizations, which are the mutual fund and its ownership of the business corporation.
Take your pause for signaling that we are about 5 minutes.
Okay, I will say a few words. The pattern I suggested with mutual funds is something we find, of course, around the world, which is that ownership of large business corporations is typically today in all countries, the United States included, in the hands of an individual or a firm or a small group of persons who are closely related or operate closely together. That is, most business corporations have a controlling owner around the world. Or most corporations around the world have a controlling owner, is what I mean to say here. And we think that, in a way, sums up what we see in organizations throughout history. Shareholder voice is not useful in managing. I think the system is telling us that shareholder voice is not useful in managing business corporations. That business corporations are better managed by managers. The managers may be engaged in a little self-dealing, but they will be better than having a gaggle of a large swarm of public shareholders debating democratically what the firm ought to do. This doesn't seem to work. Rather, in most organizations, we've stripped away the right to vote from individuals and left it in the hands of some autonomous, self-perpetuating group of owners. And that seems to be just fine. The continuing survival of mutual companies, mutual insurance companies, the best example, shows much of the same thing, I think. That delegated management, autonomous management seems to do just fine. And one needn't give the beneficiaries of these organizations strong control rights, either in the form of voice or exit or scope, to make them perform well. Let me make a qualification with scope. If we had more time, we would look harder at scope. Scope does trade off a little bit against the Hirschmanian exit and voice dimensions. it's the only place where we see a trade-off in these control devices. Otherwise, and there are reasons for this, which we won't pursue at the moment, but otherwise, not just exit and voice, but also duty tend to be confirmed, be strongly correlated. Well, I will let it go at that and answer questions. Anna, it's all yours.
Anna, we don't hear you.
There we go.
At this point, I would have liked you to take more time to finish, to draw some implication of these great frescoes that, to start with, depict how far we can go in using the same tool for analyzing a wide range of organizations, and how much in common if what we think we should have a special theory for, namely firm, have with other type of organizations. So waiting for some questions that I don't see yet in the chat. May I ask you, what implication of this decrease of correlation between the dimension of voice and exit over time?
Why are they affirmatively correlated?
Excuse me?
You're asking why are they affirmatively correlated? Why is there a positive correlation between them?
No, why there is less correlation? I mean, it seems that over time, they were more correlated in Renaissance Italy. So while the variety of combination of the dimension increased in modern society, which sort of makes sense, but I would like to you to express what do you think about?
All right, it's a fair question. I'm not sure I have a strong single answer for it. I think what we're finding principally is that voice is relatively useless in most organizations. And the reason is that that the mechanisms we have for collective choice among large numbers of people are pretty weak, are pretty poor. We have majority voting. And majority voting, as we know, is subject to all sorts of problems. At the simplest level, the mean and the median voter may be very differently situated, so that voting right off the bat, even sincere voting, leads to bad outcomes. But I think it's more than that. I think that the people who vote are often ill-informed. There's also, among those who are better informed, there are strong incentives in a voting system to engage in negotiations, build coalitions, try to destroy coalitions. And information, of course, has to be duplicative. Everybody who's actively involved in control has to have the same information. That means that a lot of people have to be educated about the same thing. Very expensive. So I think the problem is our lack of good collective choice mechanisms out there. And I think we see something changing in that, which may be behind your question. We are seeing a strong movement toward the contractualization of enterprise in the last century. That is, relations with creditors now are highly elaborated. People often point to the demise of the general partnership as achieving a fundamental change in the organization of industry. We move from the unlimited liability small partnership to the very personal organization to the large business corporation with limited liability, or to the business corporation with limited liability. And the idea is that the partnership has somehow pushed the business corporation, the business corporation has somehow pushed the partnership out of business for small enterprise. We think that's not what's happening. We think what's happening is we are starting to contractualize the control mechanism all the control mechanisms of small enterprise, and that we still have the limited liability company of today looks amazingly like the partnership of 15th century Italy.
Yeah, that's right.
In the sense that the partners typically waive their unlimited liability in de facto, and assume personal liability for the debts of the firm, but they do it by having a bank come in, a single bank come in, take subordinated, lend money to the partnership on a subordinated basis, puts the trade creditors first, bonds the firm with the trade creditors, the owners of the enterprise, the partners or the shareholders, meanwhile, sign agreements with the bank that give the bank a lien on almost all of their personal assets.
Okay, we have, can we take two questions? One from Scott Maston and another from Massimiliano Vattiero.
Hi, Henry. Insightful as always. Appreciate the work that went into this paper. So I appreciate also the difficulty of fitting in 6 centuries worth of organization into a reasonable length paper. But I was wondering whether you've got the 15th century to the 20th century, and there was a lot going on in England and the Netherlands in sort of 3-century period in between organizational innovations. And I was wondering, is those 3 centuries in the middle, are they just transitional, or are they going to fit into your framework as well?
Yeah, we think that we think we can absorb just about anything, of course, and being hubristic as we are. And the business corporation, of course, brings some familiar changes, and it's clear why. Suddenly we had industries, transoceanic shipping, railroads that required very large amounts of fixed capital that were organization specific. And you had a question of how to finance that and make your commitments credible to it. And that was the burden and the benefit of these centuries, that we achieved that with the business corporation. And it wasn't so easy to get off the ground. It got off the ground reasonably well in the 17th century in England. We have to remember that the Dutch created only 2 business corporations in the 17th century, the Dutch East India Company and the Dutch West India Company. And the West India Company went bankrupt twice before it disappeared. It never got any private shareholders. So the Dutch had trouble learning how to make these organizations work. The English succeeded. But I put it to you that we are, as I say, taking the diversity out of the ownership of business corporations, and they are becoming more and more autonomously managed, and ownership interests by the public are becoming beneficial only, not active ownership interests. And as that process moves on, we're absorbing the business corporation back into that same set of problems. We're making them look more like monasteries and guilds, more like monasteries. Guilds were full of faction. And the monasteries collapsed when there was faction too. They got too successful, they earned a lot, they built up a lot of money, and then monks started fighting over the money and what to do with it, and they fell apart. So you can be too successful. But I think that we are entering a period where we're kind of a fiduciary economy, where money is held not directly in enterprise by individuals, but it's held by large funds, mutual funds, sovereign equity funds, nonprofit endowments, whatever, and pension funds. And we don't have the public participating in corporate control. We have Jeff Bezos running the corporation as best he wants and sees fit, and and the public shareholders go along for the ride. And nobody else need to educate themselves much about what's going on at Amazon. So, so I think that the business corporation fits into the general scenario. I think we haven't hit the end of the road yet. But I think the end of the road is going to involve very little voting among shareholders on general issues. And certainly electing managers doesn't look like a very helpful thing to do. Is that responsive at all?
Oh, that's good. Thanks. Thanks, Harry.
Yeah. So can we turn to Massimiliano?
Okay. First of all, thanks for this fascinating talk. I was wondering whether you believe that there is an optimal combination between exit and voice, and whether the combination, the voice and exit, can create or can sustain a variety of corporate governance around the world.
I think the answer is probably yes, that it can support a variety of things, and that we're just now trying to figure that out. We're just now experimenting with a variety of ways we can organize a business corporation or a business organization. Small firms are clearly very different from big firms. The private equity fund, the venture capital firm, the activist hedge, the hedge fund that is adventuresome, like a private equity firm in its investments, are different entities from General Motors or Amazon or whatever. And right now we are depending upon these smaller entities, the private equity funds, firms, and so forth, to take care of the governance problem for us. If they go out there and find a firm that is badly governed, so the rhetoric goes, they will assemble a group of fellow sharks, as it were, of mutual funds that have large assets and very small research departments. And together they will threaten or take over a badly performing small company and or even semi-large company and make it more profitable. I don't know if this is going to last. I think that the number of smart private equity firms out there that do this may be limited. It's not clear that it's overall very profitable. It's an awkward mechanism for controlling firms. So, but we're experimenting, and I don't know how it's going to come out.
Great. Any other question? I don't see any other. Maybe the staff received any question privately or no? No.
Can I ask a question? Sorry.
Okay,
Hi,
great.
Professor. Thank you for the great presentation. How do you see your framework dialoguing with the discussion on the purpose of the corporation and the revisiting of the Milton Friedman principle, let's put it like this, in all of this? Do you see this connecting directly? Mark, can you elaborate a bit more on this?
Yes, I think so. I think it has strong implications for it. I think that that the present press emphasis is pushed toward stakeholder investment, stakeholder management. That is management where the managers are trying to serve the interests of simultaneously of a number of group of so-called stakeholders, which includes often the workers, suppliers, customers, the environment, the local community, and who knows what else, is doomed to fail. I presume it will not be a long-run success, that we will get bored with it and go away and do something else in a couple of decades. And that its inherent problem is its use of control mechanisms, exit and voice, to do things that they're very expensive in doing. it's famously been said, and I think it's true, that a fiduciary duty to everybody or to 3 people, or a fiduciary duty to 2 people with a conflict, who have a conflict of interest, is a fiduciary duty to nobody. And so I don't think that the courts are going to sort it out among themselves and as to what the duties of corporations are going to be. The courts are going to be sidelined by giving the corporations multiple purposes, and that the corporations themselves will become confused and will give it up. We have to remember that, at least in my formative lifetime, the formative years of my lifetime, we include the 1980s, which were a decade in which we all knew, everybody in corporate governance knew, just knew, it wasn't something to be argued, that these corporations were managerialist and they needed to be broken up. And the problem was the managers were spending too much on the workers. They were investing too much for the future. They weren't paying out enough in dividends. And the managers were taking everything for themselves or just mismanaging. And the important thing was to light a fire under these managers, make them manage for profit, for shareholder benefit, for profit narrowly conceived, and to stop coddling unions or other parties that were not on the productivity bandwagon. Today we have just the reverse, people complaining about managers who pay out too few dividends and or too many dividends and don't reinvest enough. Of course, reinvesting, empire building was the worst sin of the 80s, but now it's a virtue. And so I'm skeptical that it's going to get us very far. I think something else may be going on that may be more hopeful, which is a development of a general set of norms of business morality that will apply, that all corporations can follow, that aren't specific to some particular industry, and it will take the sharp edge off of the capitalism we've seen, the sometimes exploitative capitalism we've seen over the last 10 or 20 years, since Enron, I guess. And that would be a useful thing, I think, for corporations to think of. Maybe just because they've got the opportunity to exploit their workers doesn't mean they ought to do it. Or the opportunity they have to exploit their customers through shoddy products or misleading pricing is not a good thing to do, and they shouldn't do it. And that's true for all firms. But that's the best I can see coming out of it. I don't have much faith that it's a good idea to have corporations pursuing the interests of a variety of people whose interests are at odds with each other. I think all that we've learned since the 15th century, I would put it, tells us that's not going to work out very well. And so I'm at the least skeptical and at the worst rather cynical about this movement. Of course, it produces large returns for law firms who have to be consulted by boards of directors now to know whether they're in compliance with ESG guidelines and norms. And they got to talk to accountants and specialists in ESG matters. And this produces a great deal of volume of business for lawyers and investment bankers and accountants and other experts in the field of social responsibility. And I think that's where the impetus for this comes from, largely. I hate to say it, but so it's not an all bad thing. It may be a good thing on net in the long run, but I think it's got a lot of difficulties that are at the heart of the business.
Okay. I think I heard, I would like to invite you to raise your hand if you wish to talk, but I think Lorenzo Sacconi, perhaps. It seemed to me.
Yeah.
I heard.
I was asking permission to make a question. But the previous question is already concerning what I was interested in. So I can make a similar question, but in a more precise way related to what Henry Hansmann said us in his first part of his presentation. Because the question could be, what allowed to change the position of one category from the status of creditors, from their status to the status of beneficiary. So essentially, the idea of the stakeholder approach is that all this, there are essential creditors that should be seen as beneficiaries in terms of some of their rights or the way in which they are protected. You focus more about the relationship between the firm and owner and or beneficiary, but you also started by quoting the problem of preventing opportunities between the owner and the non-controlling subjects that are stakeholders. So it could be the case that being in the non-controlling position for some of them is so risky that it's better to enlarge the protection toward them. So creating, for example, fiduciary duties that protect them in order to allow that the company is run also in their interest. That is, for example, when there are specific investments, knowledge in human capital, which are very important, you typically would say that you are already explaining in your famous contribution that in this case there could be a worker cooperative, but of course these are only one stakeholder a time considering. But when you have a reason for considering shareholder as beneficiaries, but also specific investment of the worker are involved, could be this a reason for considering them as a second category of beneficiaries, or some combination of the mechanism that you proposed in order to protect them in a way that the management is obliged to respond to them as a second category of beneficiaries. So the reason is, the point is, why you put a category into the, as a matter of fact, you are saying that there are some that have the legal position of beneficiary or the position of creditors, and they are differently regulated by, but some category that you are, for example, employee, are put in the category of creditors, would be transit to the category of beneficiary, and so you should provide for mechanisms that balance between them. So you could say that there are costs in terms of the process of collective decision, but these costs could be lower than the cost of allowing opportunities from the owner to the non-controlling, which is a form of opportunities that you are consider at the very beginning of your statement or your paper. Consider three kinds. You said that the less important is between managers and owners. So there is this form of opportunities which is equally important, and maybe this entails that some of them should be protected in a similar way, in a way which is similar to what you consider a protection of.
Okay, thanks, Lorenzo.
All right. Good question, and let me try to say something relevant to it here. It covers a lot of ground, but just a moment, I have something bonging in my background here. Now, the line between a creditor and a beneficiary is a very hazy line, and one needn't be all, or one can be both, I think. And I think it's helpful to think of many of the people who contract with a corporation, with an entity, an organization, as sharing aspects of both. Maybe they're managers too, to some degree. But I think it's most helpful to look at them as creditors, workers as creditors. in our schematization here. There are problems with contracting, of labor contracting. It's, I think this is a bad time in the United States for labor contracting. I think we're pretty far away from having an effective system for it. And it has to be protective of workers. But the means of protecting workers needn't be giving them control rights. And I think that's a poor method of doing it. You could give them bargaining rights, more effective bargaining rights, as they used to have in the United States when unionization was widespread. Unionization clearly has its problems too. I think we look back on it with a bit of a rosy glow now, but it's not a perfect solution. But I think one has to, we live in a complicated world. Organizations are complicated. I think that that managers dealing with workers have to appreciate that partly they're bargaining on behalf of their shareholders or the corporation itself to extract the most rents out of these workers as possible. And at the other hand, one is being a fiduciary for them and not extracting too much. And even if you won't get a reward for it in the terms of better employee discipline or generosity toward the enterprise or whatever. What I think is that efforts at employee governance are not likely to be successful. Putting employees on the board. I love Elizabeth Warren. I think she's a great person, but I think that her least convincing proposal is to require 40% of the board be X or Y or whatever. There's much to be said for short-term efforts to force organizations to take more women and people of color and so forth. I think they'll discover that life works just fine with all these people on the board, maybe a little better than it used to. And we're just breaking down habits here, bad habits and bad prejudices, injurious ones, even to the holders of the prejudices. But that's different from saying that in the long run, we ought to try to have the corporation managed by a group of different interest groups that will somehow bargain things out among themselves in the boardroom. And so I would think the best we are likely to come out of the current situation with is more of the same. That is, workers' rights that are where they are truly endangered, where they are reinforced by legislation. The tax law, of course, is one of those. Control the distribution of income, which is getting out of hand, and health and safety, pension rules, health insurance, and that sort of thing are all things society can do to make workers better off without involving these conflicts of interest at the organizational level. And I think that's what's to be avoided. To try to solve the welfare of workers in the boardroom at Amazon or something, or at some more diffusely controlled company is probably not a smart thing to do. And so I'm doubtful that we're going to find, workers are creditors. They need some protection, and we've got to find some way to guarantee them protection, just like all creditors need protection, or they won't deal unless you give them some protection. I focused on financial liquidity in my talk, but it goes to worker safety and so forth too. If you know it's an unsafe plant, you're not going to want to work for it. And so the company's got to try to convince you it's a good place to work. I think that's true for all patrons of the firm, all beneficiaries of the firm, all people who contract with the firm. And I mean to see this creditor relationship taken broadly. As encompassing problems with employees or that employees have with the firm and so forth. but I don't see much coming out in the way of corporate governance here. I think it's not a corporate governance problem.
Okay.
I think it's a contract.
Maybe this is opening a second round and another debate on a big other issue. So given that we have another session afterwards, we have to open. We thank so much for this wonderful and stimulating talk. Wait, I don't know. And